in. So welcome everyone to the CLE webinar on advising the financially distressed business in the era of COVID-19. The webinar is being sponsored by the University of Illinois College of Law. I'm Bob Lawless, the Max L. Rowe Professor of Law at the College of Law, where I teach and write about bankruptcy law. So my role here today is to serve as the moderator. I'm going to talk quickly about filing statistics. In addition to serving on the faculty, I'm also an alumni of the law school, just like our panelists, just like many of our attendees. My father was a alumni of the law school. Indeed, was a student in some of the first classes taught by somebody named John Creditor. So when the law school, approached me a few weeks ago about putting together a CLE focused around our alumni, I knew it wouldn't be a difficult task because of the College of Law's long leadership in the area of bankruptcy and commercial law. And most recently, that leadership has been, the point person of that leadership has been Charles Tabb. He's taught, I think, several of us on the panel. He's now the Mildred Van Voorhees Chair in Law Emeritus at the College of Law. He's not able to join us today, but I wanted to acknowledge his long-time leadership in the field and acknowledge he's one of the reasons that we're all here today. Given how busy we are, given how busy our panelists are today, we're very fortunate to have these three alumni of the College of Law join us to talk about advising financially distressed businesses in this difficult time. First, Jill Nicholson is a partner at Foley & Lardner in Chicago. She is the immediate past chair of the firm's national bankruptcy and business reorganization practice. She has a long list of recognitions. It'd probably take up the rest of the webinar to list all of them. She represents a broad array of clients, and it's really fantastic she could join us. Next, Brian Shaw is co-chair of Fox Rothschild's Financial Restructuring and Bankruptcy Department. Brian is a past president and chair of the American Bankruptcy Institute. He represents both debtors and creditors in reorganization and liquidation proceedings, and he's been involved in some of the early SBRA cases. Finally, Jamie Sprayragan is a restructuring partner in the Chicago and New York offices of Kirkland & Ellis, and he served on Kirkland's Worldwide Management Committee from 2003 to 2006, and then again from 2009 to 2019. Jamie is a Chapter 11 leader and has been involved in many large corporate reorganizations. Again, I could probably take the rest of the webinar and listing them all off, but to just name a few: Energy Future Holdings, Caesars Entertainment, United Airlines, Toys R Us, and of course, many others. It's really a privilege that for the our three alumni who have joined us today for the session. The plan here is that I'm going to talk very briefly about what's been happening in terms of bankruptcy filings. And then I'll turn it over to Jamie to speak about some developments overseas. Jill and Brian will then turn to the new Small Business Reorganization Act, or SBRA, or Subchapter 5, whatever you like to call it. I was thinking as I was preparing my notes here, we've really got to settle on what the jargon is that we're going to refer to this as. But that's the plan. In terms of questions, if people have questions, if you could perhaps put it in the chat, I will do my best as the moderator, time permitting, to work those in. So if you have questions, put them in the chat, and again, I'll try to take a look at them as we go and ask some of the panelists. So as I said, the first kind of thing I wanted to do is talk a little bit about where we're at with the bankruptcy filing data. There's been a lot of talk about bankruptcy filings spiking. Seems to be a common word, gets thrown around a lot today. So for those of you that follow my posts on the Credit Slips blog, you probably know I spend a lot of time thinking about the bankruptcy filing rate and doing all sorts of mathematical models and like that. And I guess where I wanted to start off by saying, if somebody tells you what is going to happen with bankruptcy filings, the first thing to realize is they don't know. No one knows what's going to happen. I can run a mathematical model. I can plug it into my computer, predict what's going to happen with bankruptcy filing rates. But all that does is extrapolate from past correlations. We're assuming that going forward is going to have the same relationships as what happened in the past. And who knows whether those correlations and relationships are still going to be valid in a COVID-19 world. So, although you can count me as one of the people who think it's likely that bankruptcy filings are going to go up, I don't really think we know the shape or timing of that curve. Is it going to be a gradual increase? Is it going to be a quick run up? Is it going to be a quick spike? There's obviously a lot of economic pain out there. So it's hard not to see a world where bankruptcy filings don't go up, but I can create countervailing narratives that perhaps governmental action or a tightening of credit is going to drive down the number of new cases. Again, I think there's just tons of uncertainty. So what you can do is go back and look at what has been happening. I think that's informative. And for those who've not been following it closely, the total filing numbers have been down dramatically. So this is a chart showing the last 10 years of monthly filings. So we're right now over in the very far right hand, and you see there the big drop. This table shows the filings over the last year by month. And we're really down for the last 3 months in terms of these are total bankruptcy filings. And I always do this on a per business day basis because the number of days in a month matters to how many filings there are. And you can see, right, April was down 46%, May was down 36%. I saw some people saying, oh, well, maybe this is right there. The decrease wasn't as big in May. I looked, the first week of June, we were down 42.3%. So that's about 8,000 filings. There were over 14,000 filings a year ago, the first week in June. Because this CLE is mainly consists of people in Illinois, University of Illinois alums, I wanted to spend a moment looking at the Illinois patterns. It's the same. The filings have been dropping in Illinois. Here's the monthly chart. So this is the last 10 years. And this is the monthly chart, and again, here in Illinois, right, we're down. The drops in Illinois and total filings have been in the 40s. I don't know that there's any hard data on why this is happening, but I think there are 3 likely reasons. First, the stay-at-home orders are keeping people out of attorneys' offices and attorneys out of courthouses for that matter, right? You can do a lot of things electronically, but you can't do everything electronically. I think a second reason is people have a lot on their plates. We often think about bankruptcy as an economic decision, but it's sociological and psychological as well. People have a lot on their plates. Consulting a bankruptcy lawyer is just not making it on the top of a lot of to-do lists. I think a final reason we're seeing this big drop is there's a lot of economic turmoil and people are waiting to file until there's more certainty about what things are going to look like. So I don't think you can point to any one factor as to why there's been this big drop off, but there has been just this general decline. And I think, again, like many things in life, it's multi-causal. On the Chapter 11 side, so this is the last 12 months, there has been a run-up in Chapter 11 petitions, right? So, right, the right-hand side of that chart, you see their bankruptcy filings have been running up toward the end of the last few months in April and May. And this produced a lot of headlines, frankly, from organizations that should know better, like the Wall Street Journal. Pained me a little bit to see the American Bankruptcy Institute report this, right? Bankruptcy filings are up 48%. In May, right, bankruptcy filings are spiking. Well, if we zoom out bankruptcy filings in terms of time, so here are the last 5 years, right, what do you see? Well, you see all these spikes, right? You see bankruptcy Chapter 11 filings. Let me make clear, right, we're not only talking about Chapter 11 filings, you see all these spikes and they bounce all over the place. And the reason for this is that the Chapter 11 counts, the statistics include every Chapter 11. So if you have a corporate affiliate and a big corporate group that gets counted as one bankruptcy filing, one Chapter 11, and the numbers bounce around a lot because of the foibles of just coincidence that in 1 month, maybe there's a big corporate group that files with a lot of affiliates. And indeed, this is exactly what happened in May. So this is a download from Pacer. So these are all the affiliates from LePan Quotidian that filed Chapter 11. They were 1/7. LePan Quotidian counted for 1/7 of the Chapter 11s filed in May. It's a lot of hard work to go through and do this right. You have to go through the time periods and eliminate all the affiliates. Ed Flynn at the American Bankruptcy Institute did that hard work. I think many of you might know him or know of him. used to be at the administrative office, and Ed tells me that if you go through and eliminate the affiliate filings in 2019 and 2020, Chapter 11s were actually down in March. They were slightly up in April if you do that task, and I think maybe there's a slight modest rise in Chapter 11 filings, but there's certainly not been this big upward trend like you've been seeing in the headlines. Where there has not been just a modest rise, but a huge rise is in large public company filings. So moving from the world of all Chapter 11s just to large public company filings, there's been a big spike. So this is one area where there's been a big run up. And what do I mean by big? Well, it's $100 million in assets using 1980 dollars. So this is apples to apples. That's about $311 million today. So companies 311 million or more, there's as many of those in March, April, and May as there were in the previous 12 months. I think it's hard not to see this as a big trend. In previous recessions, we saw these numbers spike again. So the extent I think you can start saying, well, here's a trend we're going to see, you're probably going to start seeing this big, large company bankruptcy. So my job was to set the stage a little bit with what we're seeing in terms of the bankruptcy filing rate. And with that, I'm going to turn it over to Jamie to talk about developments overseas. So Jamie, take it away.
Okay, thank you. Appreciate the opportunity to talk to you all today. And I think the previous slides set the stage in the United States. Similar things are going on around the world, and a lot of it's anecdotal, and a lot of it's people are still reacting to the crisis, and each country has had the health problems running through it at sort of different speeds and different ways. And so there hasn't been, if we could go to the next slide, there hasn't been really any magic bullet or one uniform approach. But I would say if you went up to, say, 500,000 or a million feet of what I'm going to go through, interestingly, the changes that countries have made around the world in the main have been doing something that brings either temporarily or permanently their system closer to our Chapter 11 system in one form or fashion. So generally, I would say the universal problem that is trying to be addressed is to support viable businesses, but don't prop up the zombies, that is those that were sick even before the crisis. And they're obviously trying to respond to a very dynamic situation where the facts are kind of unknown and it's not economically driven, at least in the first instance. There are a whole bunch of common themes when I mention bringing systems closer to Chapter 11. In many places around the world, directors face risk of personal liability to a much greater degree than they do in the United States. And that tends to cause precipitous and sometimes unnecessary insolvencies, because directors, rather than take the risk of running afoul of whatever their country's wrongful trading laws or other type laws, will file to avoid the risk of personal liability. So what you have seen is in a lot of countries, and I'll get to some specifics, relaxation of the director's risk of personal liability. It's been approached in a few different ways. There's also in a lot of countries a mandatory filing obligation if you get in whatever their definition of some type of insolvency, and there's been a relaxation of mandatory filing requirements. There's also been stays and limitations on creditors being able to take action. There's been an encouragement to their form of DIP financing, some sort of rescue financing. And there's been, in some places, either responsive to COVID or something that had long been in the works being accelerated, some new restructuring and insolvency procedures. And then there's been some direct fiscal support and stimulus from governments and tax deferrals and relief. That's beyond the scope of what I'm talking about. I'm really just focusing on the system, the insolvency system that's in place. Some of these have been put in temporarily, and some of them have been put in permanently. Some of them are for a set period of time, and some of them are based on some sort of test during the emergency period as may be declared. Now, I'm going through this, one, pretty rapidly, and two, in a huge summary fashion. If people are interested, I would commend to you looking at the American Bankruptcy Institute International Committee site, where they go through, I think it's 21 countries as to what they've done. Insol International, a big international insolvency organization, also has a report that covers 38 countries as to what they've done. And my firm, Kirkland & Ellis, has on our website, we've covered Europe, UK, and Germany, what's been done in those countries. So there's a lot more detail for anybody who's interested. If we go to the next slide. So with respect to the relaxation of directors' risk of personal liability, so let's just run through what's happened in a few countries around the world. So in the UK, there's pretty big exposure for personal liability for what's called wrongful trading, basically continuing to do business with trade vendors while you're unable to pay your debts. And what has gone in is directors now can't be liable for a worsening of the company's financial position from the beginning of March through the end of June, subject to further extension. That's for us in the US, that's actually kind of what the law is already, but that's a big change there. And similar change was in New Zealand, who has a similar system to the UK, but not the exact same. But as long as the company was insolvent at the end of 19 and the director has some reason to believe the company will recover, there's a safe harbor through, a safe harbor commencing in April 3, 2020. And there isn't an end date on that, that the actions of the director won't be reckless if the director reasonably believes that the company's liquidity problems are coming because of the COVID problem. So that's a lot of protection in New Zealand. In Singapore, for a director who's incurred debt in the relevant period will have a defense against personal liability for incurring debts without the reasonable prospect of meeting them in full. It's pretty similar to what the UK did, but not exactly the same. And similar in Australia, which had probably the most draconian of the sort of top industrial economies exposure to directors. Directors there aren't going to be liable for incurring debts while insolvent or insolvent trading, that is, not being able to pay their trade creditors, in the 6-month period starting in March 25, 2020, again, subject to extension. And Germany, which also had pretty draconian rules, suspended directors' obligations regarding trading, really prohibiting trading in the zone of insolvency between March 28 and September 30, which could be extended all the way through March 31, 2021. So those are some kind of interesting moves around the country. Yes, next slide. You're channeling me. Then I mentioned mandatory filing obligations. We don't obviously have that in the United States, but in Germany they have what's called the 21-day rule. You have to file within 21 days of cash flow or balance sheet insolvency. That duty has been suspended through September 2020. Again, subject to extension through March 31, 2021. But they introduced a sort of a squishy thing. The illiquidity must be temporary and caused by the pandemic. So query whether, if you're a director, this one, if you violated, you can go to jail. So whether this carve out about being temporary and caused by the pandemic will take away the risk of the directors or really encourage non-filings. We'll have to see what happens. Bulgaria, similar to Germany, but not an exact 21-day rule. Again, they suspended that until 1 month after the end of the state of emergency. Austria, pretty similar, duty to file within 120 days. And that was extended from 60 days, so they gave them a little bit more time. And no requirement to file for over-indebtedness occurring between March 1 and June 30. France, they suspended the duty to file really from basically March to August. Spain, they suspended it all the way through the end of the year. Luxembourg's just said during the state of emergency without putting dates on it. and Switzerland did it until October 2020, but again, had some subjectivity in it because it says provided the company was not over indebted at the end of 2019. So those are moves in the right direction. They're not going to be perfect, but they're hopefully will keep a lot of companies that might be able to muddle through if COVID doesn't have a relapse. If you go to the next slide. There's been a prohibition on a whole bunch of creditor actions that could be taken, either a stay or a suspension. Italy, basically you can't, no involuntary through June 30. That was starting on March 9. Same with Spain, and that's through the end of December. And they did a suspension of evictions for residential tenants too, but not for commercial tenants. The UK, a winding up petition, which is sort of like an involuntary, only possible where the insolvency is not because of COVID, and that's through June 30, subject to further extension. And they're looking at there's a lot of legislation pending in the UK. They're looking at the introduction of a standalone moratorium, and commercial tenants cannot be evicted. That's not done yet, although that was tried last week while this legislation was pending, and the court said, well, we think the legislation is going to pass. So even though the law allows it now, we don't think it will allow it next week, so we're not going to allow it this week. So that was kind of interesting. Germany, again, suspended the involuntary from March 20. Could be extended. And restrictions on landlords, pretty common theme about restricting landlords. Turkey, temporary suspension of creditor. And same, you can't evict commercial tenants. Russia stopped petitions for insolvency from April 6th to October 6th. If the business is a systemically important company or in one of the most impacted industries like transport or hospitality. There's a few others. Australia, they raised the monetary threshold. In Singapore, also raised the monetary threshold. And they raised the time limit to respond from 21 days to 6 months so that you can buy some time. And India raised the minimum default rate 100 times, which is pretty significant. If we go to the next slide here, there's been encouragement and protection for rescue financing, what we call DIP financing, but it's different in a lot of places like Colombia. They put in something pretty close to DIP, and so did Singapore. Italy and Spain, they have rules that generally insiders giving loans are automatically subordinated no matter what. They suspended that to encourage lending. Germany, they did a similar thing that shareholder loans are not automatically equitably subordinated if granted before September 30 of this year and paid by September 30, 2023. So that's in Germany, usually if a shareholder gave a loan, it was automatically subordinated. So that's a lot of protection. Interestingly, the UK, even though they have a lot of legislation pending, they haven't done anything about post-petition financing in their draft legislation, which we think is kind of a pretty big missed opportunity for them. If you go to the next slide, which is actually the last one, there's been an acceleration of planned reforms as a result of COVID too. Again, some temporary and some permanent. The Netherlands has what they call the Dutch scheme, which is really modeled on US Chapter 11, a little bit on the UK scheme of arrangement, but they're really trying to encourage the Netherlands, especially with Brexit, to be a situs of like a Delaware type of thing in Europe. And their courts will be holding hearings in English, and you can submit papers in English. So it'll be interesting to see how that works out. As I said, the United Kingdom is in the process, even before COVID, of enacting, or at least talking about enacting legislation that's, again, a long way towards Chapter 11. We'll see if that gets done because it hasn't gotten done yet. And then in the world of responsive reforms, New Zealand put in what they call a business debt hibernation regime. And interestingly, you can have something that's binding on all creditors if it's approved by greater than 50% in value and number. So similar, lower threshold in value, but similar to our cram down test, or avoiding cram down, and having an automatic stay, a moratorium during the proposal stage. Mexico put in an emergency insolvency regime to make it easier for companies to go into insolvency to deal with COVID. And Colombia also put in a temporary insolvency and restructuring regime, supposed to apply only to companies affected by the pandemic. That's for 2 years, but it could become permanent if it works out. Interestingly, Italy went the opposite way. They debated for 7 years a new code. It was supposed to go into effect this August, and they delayed it now to September 21. My personal feeling is that was a mistake. It was an advancement, and so they delayed that. They just thought it was too much to do during the pandemic. So that's sort of a quick tour around the world, and there's lots going on, as I said, with the other materials I refer you to. But as I said, if I went back up to 500,000 feet, it's interesting. All of these are basically borrowing from pieces of Chapter 11. So hopefully that's helpful. And if we have time for questions at the end, I'll be around.
Yeah, thank you very much, Jamie. Yeah, as I was listening to that, I was thinking, yeah, if someone maybe is not representing a Netherlands company in a Netherlands reorganization, you probably represent a company that does business with companies that are touched by these reforms all around the world, and it gives us a good sense of what we might also see in terms of reform in the United States. Although, as you pointed out, a lot of what the reforms in other countries are to move toward U.S. Sort of solutions. So, with that, let me turn it over to Jill and Brian to talk about the Small Business Reorganization Act. I realize we didn't work this out first. I don't know if I'm handing off to Jill or to Brian, but I'm sure they will figure it out and tell me.
No problem. This is Jill. I'll take the baton. So on the opposite spectrum of what Jamie was talking to, we have the Small Business Reorganization Act that was enacted last year. And as many of you know, when effective, went live on February 19, 2020. It's interesting because, as bankruptcy lawyers, we all love new legislation and the quandaries that such legislation presents to us. And I think the SBRA is no exclusion to that. With it certainly being in its nascent stages, there's really a plethora of litigation that has spun off. And we'll cover a number of those topics as Brian and I move forward on these slides. So relatively untested, but every day I'm seeing new decisions and new disputes that are emerging. For obvious reasons, the SBRA has its genesis that, there was lobbying for a significant period of time to get something that was more affordable and streamlined for small businesses, to avoid a one-size-fits-all approach to Chapter 11, to the Chapter 11 process. And so what we see is the SBRA was enacted, and if you could move over to the next slide for me, Bob. So this is subchapter 5. It's intended for small businesses only, and a small business is defined as a person engaged in commercial or business activities. So a little bit of historical background here. I know there was significant lobbying of Congress to have a fairly robust cap on aggregate non-contingent liquidated secured and unsecured debts, or that cap. Despite that lobbying, Congress initially placed it at $2.725 million. Of course, as we see the other provisions in the code, index for inflation every 3 years. Now, interestingly, the CARES Act bumped that up to $7.5 million. But bear in mind that relief is fleeting, and that will sunset absent any kind of further action by Congress on March 27th, 2021. So let's move to the next slide here. So who really falls under this? It's a person or an individual or corporation or partnership. It's a person engaged in commercial or business activities. Interestingly enough, what we're seeing is, some dispute as to, well, how does this work? And so what if you have a business that's winding down or has residual business. Interestingly enough, court in the bankruptcy court for the District of South Carolina, held that it really could address residual businesses. So, you know, again, the point of this and the focus was to avoid all of the procedural hoops and time-consuming and costly provisions that you would see in a large-scale Chapter 11 to help those small businesses out there. So with that, I'm going to turn it over to Brian to talk about the three big changes you see under the, as I like to call it, the SBRA.
So before I do that, I at the risk of taking you out of the flow, we had a good question, and we've got time, so I think I'm going to throw it in here because it's on eligibility. So the question, as I understood it, is basically this: is the debt threshold is aggregated for all the corporate affiliates?
I believe it is.
Yeah,
but I would have to,
yeah, it is, and so the question was, what if you have an affiliate that's under the threshold that wants to file a loan, but is part of a larger corporate group that's over the threshold?
Mm-hmm. I think you have an issue here. I mean, certainly if you have a secured lender who is going to be feisty in the case, I think you could have certainly an issue arise based on the eligibility requirements.
Yeah, and the question, which I think is a really good one, points out that the definition talks about affiliates who are debtors, and you are not, if there's a non-filing affiliate, arguably you wouldn't count that non-filing affiliate because they're not a debtor within the definition of the bankruptcy code. But my guess, and I'd be interested in your take on this, is, and I think you've already said this maybe, is you're going to write a brief on this, is basically what to plan on this being an issue if you've got a creditor that wants to oppose it. I think this is going to be a theme. There's a lot of open questions.
No question about it. I think that you're going to see more litigation about this. You know, I'm a member of ABI Listserv, and I can't tell you the volume of interesting and intriguing questions I see. And let me just throw in and kind of go off the slides for a second. Here's one that just emerged today, which was a reputable title company asking the issue of, well, what about the application of 1141 for post-confirmation sales of real estate and releases of liens, and what does that mean? And does it 1141 apply to subchapter 5? These are questions that are rolling in every day that are wrinkles that we're seeing. And I think, again, this is just the tip of the iceberg. So all great questions, but you know, and reasonable minds can differ. So I think, again, you're going to see just a spate of litigation, notwithstanding the good intentions to make this more streamlined and affordable. Whenever something's new, people are willing to challenge it. So I think that's yet to be seen, Bob.
Yeah. So and thanks for allowing me to interrupt. But it was an eligibility question. It seemed like a good time to work it in. So with that, Brian.
Yeah, hey, Bob. You know, it actually provides a really good segue. And for the record, I call it the SBRA too. And I think that's going to be the living acronym and name. But the points that Bob and Jill just made are important because, you know, this is a new chapter, so to speak, or subchapter in bankruptcy land. And if you're practicing, you hear people asking about this all the time. And many people hear, oh, there's a new subchapter of the bankruptcy code. It's bankruptcy light. This is great. It's going to cost nothing. Can you do it for $15,000? And my hands are moving around. I should turn off the camera. But, you know, ultimately, it is bankruptcy light, but it's not bankruptcy any less complicated. And if anybody's on the phone who does Chapter 13 work, they understand exactly what I mean. Chapter 13 has remarkably complex legal issues, and they don't go away just because you're dealing with a lot less money and a smaller case. The fact is that they sometimes go away because the economic practicalities of the case require it, but you can find yourself with really complicated issues, and if you're an unfortunate Chapter 11 practitioner that lands in there unexpectedly, you can be really confused. The same is going to be true with subchapter 5 under subchapter 11, despite the somewhat accurate, somewhat incorrect labeling of bankruptcy light. So why is it called bankruptcy light? And it's called that because of these principal three big changes, because all of these changes do affect situations where costs can be increased in the bankruptcy case. The first one is there's an appointed standing trustee instead of an actual unsecured creditors committee. In extreme circumstances, the court could still appoint or ask for the appointment of a committee, but the purpose here was to relieve the smaller cases of the economic burden that comes along with an appointed creditors committee and replace it with essentially somebody who is a fiduciary to the estate who will sit there and, in theory, protect the interests of the unsecured creditors and the other parties who would normally have some protection, or at least in theory have some protection from a creditors committee. Second of all, only a debtor is authorized to file the plan. 1189 gives the debtor 90 days, only they can file a plan. One of those areas that will probably start to get litigated shortly, because we've just run up on 90 days since the first cases are going to be filed, is what exactly happens if the debtor doesn't file a plan in 90 days. But we will see on that. I would expect to see motions to dismiss or convert under 1112. And possibly the biggest change is the replacement of the absolute priority rule by a disposable income test, which puts the equity holders of smaller businesses in a position where they can, if they meet certain tests with regard to their plan and plan payments, they can maintain their equity position in the company post-reorganization or post-confirmation, which is a major change from what I would call mainstream Chapter 11, and it saves money because it puts equity in a position where they don't have to meet the new value test and open up the bids on equity to some type of auction process as set out in the 203 North LaSalle case. Just a couple of other real quick cost saving things that are built in here. In some cases, this is a big deal. You don't have to pay your quarterly U.S. trustee fees. In addition, there's not a requirement of a second disclosure statement in connection with the confirmation hearing, which cuts your confirmation-related hearings in half, cuts your paperwork in half, and does make the process a little more streamlined. One of the other changes under the Act as to Chapter 11, traditional Chapter 11, is that two things. One, in an effort to keep the case moving, there is a mandatory status conference before the court, regardless of what else is going on in the case and how many times you've been there, that is required to be held within 60 days after the filing. That is, in theory, the court's way and the process's way of making sure that the debtors are on track for the short time frame in the case. As I said earlier, under 1189B, plans of reorganization are meant to be filed or have to be filed within 90 days of the filing of the bankruptcy, which is also a tight time frame when compared to the longer time frame under traditional Chapter 11 and 1122, I believe it is. So ultimately, the big question there is, okay, you guys codified a shortened time frame, presumably to make creditors happy in a situation where they probably generally weren't happy, but what happens when that 90-day deadline is not met? Subchapter 5 doesn't say much. It doesn't say anything, actually, other than the fact that there are circumstances where the debtor can seek and get an extension of time, but it has to be based, again, under 1189B, it has to be attributable to circumstances for which the debtor should not justly be held accountable. So, let's go ahead and talk about potential issues there. Does COVID-19 count? We've heard rumblings from the U.S. Trustee's office here in Chicago that they don't think it does count. because you went ahead and filed the case during COVID-19. You knew it was there, so how could it be unexpected? The flip side is, yeah, we all know COVID's here, but we don't know when things are going to get back to some kind of normal, and we don't know what that normal is going to be. But I expect that we will start seeing a few decisions on this particular issue in the next few weeks, simply from timing. May 19th, 90 days later is about June 18th, or February, March, April, May 19th. So we should start seeing some issues there. With regard to the standing trustee, this is interesting. The SBRA, in part, was a commission that the American Bankruptcy Institute did on Chapter 11 reform about 5 years ago. In the context of the discussion that led to something similar to what we have now with the SBRA, the ABI was trying to, the commission was talking about replacing essentially the committee role with an estate fiduciary. Ultimately, you got a standing trustee in the code that was passed by Congress. The standing trustee is not like a panel trustee. It's not like the U.S. trustee. It's a new entity that does have a fiduciary obligation to the estate. It's more like an independent monitor, more similar to what you have in Chapter 12 and 13. Most of these people are all on a short panel by region, by district, and they're considered standing trustees. Again, a little more like Chapter 13 than Chapter 7. This trustee does not take over the debtor's business. This trustee does make sure the case stays on the tight time frame through confirmation, and depending if it's a consensual or non-consensual plan, which relates to if all the classes approve it, they will be gathering and in charge of plan payments after confirmation, and they ultimately get compensated on a percentage basis of distributions, which is the cost of which is offset by not having to pay quarterly fees. The standing trustee has certain duties. Some are in all cases, some are in cases where the debtor isn't performing the duties as they should or it should. That includes accounting for all property received by the debtor and all property of the estate. They are allowed to examine and object to claims against the debtor. They are allowed to review the debtors. They're actually obligated to review the debtor's financial condition and business operations. They are charged with reporting any fraud or misconduct, assisting, and my opinion, possibly their most important role in the context of small Chapter 11s is they're also there to help facilitate what in a perfect world would be a consensual plan of reorganization. They are usually, that is the first thing in my experience in the few that I've filed, that's the first thing they raise is let us know if we can help in getting cash collateral orders taken care of, working on other disputes with secured creditors, and then more importantly, trying to come together with a plan that's acceptable to everybody. Jill?
Sure. So on the next slide, we have only the debtor can file a plan, which is a material and significant change here to Chapter 11 practice. And also it eliminates the need for a disclosure statement. And my takeaway was, or is from this, is when you have a case where the aggregate debts are under 2.7, that may make sense. When it starts reaching, 7.5, it gets a little dicier because you're really taking away from, say, for example, putting my secured lender hat on or creditors hat on, you're taking away some leverage, which is to file a competing plan. And it makes sense on the small business case because when the aggregate debts are relatively de minimis, because the whole point is to move quickly. As that cap increases, sometimes the issues become a little more complicated. And to Brian's point, again, it's a function of dollars, right? I mean, Chapter 13s can be extremely complicated with very juicy and interesting issues, but it's a question of dollars and what's the highest and best use of those dollars, and perhaps it's not litigating, or in these instances, filing competing plans. In terms of the elimination of the disclosure statement, my personal view of this is I am relatively troubled by it, just because the point is, I think arguably the more sophisticated the case, the less that you would need a disclosure statement, because you have very smart people reviewing this. And in smaller cases, you have circumstances where perhaps trade debt to mom and pop shops don't fully understand or appreciate what the plan means. So I tend to believe, or my personal view is this is backwards, but that's not my call, so of course. But in fairness, the court still has discretion to order a disclosure statement. My view of this is that I think judges would be hard-pressed to order that if, in fact, the plan's streamlined, it makes sense. Someone, just the average trade creditor could understand it. So I think that if you're going in saying you want a disclosure statement, I just don't see that kind of relief in the court's discretion being readily available. Next slide. On the absolute priority rule, this is, the SBRA leaves it unchanged for secured creditors, and as you can see, this slide talks about it, but let's move to the next slide, because here is, I know we referenced this, Brian did, the projected disposable income test. So it changes, right? This looks more akin like a Chapter 13, where you have creditors receiving projected disposable income. And what does that really mean? It includes post-petition income and income that's received by the debtor that isn't needed to pay the ordinary expenses, just to continue operations. So basically, anything that's above and beyond that would be used to pay unsecured creditors. Now, again, the CARES Act presented a bit of a wrinkle here, because the issue is, well, do the government payments that you receive under the CARES Act, for example, the PPP, payroll protection program, assuming this is, actually there's an issue of dispute with the PPP loans, which we'll get into a little bit later here, but does that constitute disposable income or not? And that hasn't been resolved, as opposed to when you look at maybe another chapter where it's expressly or explicitly excluded.
Yeah, Jill, it's Brian. Just as a caveat on that point, if you've got a PPP issue with a small business debtor, it in and of itself, all of the issues that surround PPP, and it can just easily add a real 15%, 25% to the cost of this case, simply because of the confusion regarding the treatment of those in bankruptcy and whether you can go in bankruptcy. So it's something to think about, because one of the issues with the SBRA is it does allow flat fee Chapter 11s. And if you're thinking about that, you should figure out if your debtor's got a PPP loan in place and what unique and novel issues are going to come up because of that.
Right. And this is Bob. Yeah. I was saying this is Bob. And here, right, the issues are, is it, to what extent is it a loan? To what extent the forgiveness generate income? If it's a loan, what does it do with the debt cap? Those are the sorts of things you're referring to, Brian.
Oh yeah, I mean, and then the first one is absolutely the debt cap. It's you're supposed to have liquidated and non-contingent numbers to calculate that. Well, what's conditionally forgiven loan count as?
No question. And I would also add to that, again, we'll get it in the later slides too. What if your client wants to access PPP loans post-petition? I mean, I'm seeing, if anybody want to reach out to me, I have reaching out to folks who've been litigating this in Hidalgo County, for example. They've just filed a motion for direct appeal to the Fifth Circuit as to the ability to use PPP loans. And I'll explain how this became such an issue. But to Brian's point, if you're looking for a fixed fee, you've got to build this in, because the litigation is rampant, especially if your client wants to tap that resource. And
you're also going to have take some time to explain to the secured creditor why it's not their cash collateral, and when you use it, you're not immunizing their collateral.
That's right. All right, next slide, please.
Sorry.
So preference law changes. This is just a simple slide stating what a preference is, which I'm sure most of the seasoned practitioners will know what this is. So we'll move to preference law changes. Next slide, which Brian will cover.
We're here.
So with regard to, well, hang on, you moved on me. With regard to the preference law changes in the SBRA, some of these are sort of a continuation of some changes that were made a few years earlier to deal with at least what some people perceived as I'll use the term predatory preference cases, where you were filing suit for relatively small dollars in a foreign district against defendants that basically had two choices: defend the suit but pay as much money defending the suit as the demand, or just pay the demand. And the result was limiting how and where certain small preference cases could be brought. So in this case, the first chart just says very simply, now I'm,
You
well,
want that slide?
no, that's fine.
Okay.
I'm just, no, I'm good on this one. So the first couple of slides really deal with the fundamental elements of a preference claim. And as everybody knows, you're talking about payment on an antecedent to non-insider within 90 days. That goes ahead and allows them to obtain more than they would in a Chapter 7 on the assumption that they got 100% payment for whatever they got payment for, and they're not getting 100 cents on the dollar in the 7. But there's also some very standard affirmative defenses that get asserted in most cases, including ordinary course of business, subsequent new value, and contemporaneous exchange for new value. And ultimately what 547B was changed to was to require plaintiffs, trustees, debtor in possessions, whoever is bringing the suit, to conduct some reasonable due diligence in the circumstance of the case and taking into account a party's known or reasonably knowable affirmative defenses. This was in large part a response to mass preference cases where people were getting hit and left and right with demand letters, and these demand letters wouldn't even acknowledge that the creditor was owed a significant amount of money that would entitle them to a dollar for dollar reduction of their preference liability under the subsequent new value defense. In addition, if you think about the ordinary course of business defense, you think about subsequent new value, you think about contemporaneous exchange for new value. These are all defenses that the debtor was a party to. They were a party to these transactions. So the concept that these debtors aren't going ahead and taking a peek at their own records to go ahead and acknowledge defenses got to bother some people. As a side note, I will tell you that this was less of an issue in the Seventh Circuit, and I don't have the site, but the Seventh Circuit for a pretty substantial period of time now has required, in theory, under case law, that people do take a look at obvious affirmative defenses in bringing a suit. And this is not just a bankruptcy issue, it's in any type of lawsuit. The other issue is they expanded what is called the venue safe harbor for small preferences, which I referenced previously. Initially, the protection was for preference claims up to $10,000. If the claim was less than $10,000, you had to sue the defendant in their home district. That amount has been raised to $25,000. And that's really the extent of the preference change. I don't know, if I had to guess, you probably are going to see this result in even less preference cases being brought in the small business cases, because having to go to a home district requires costs that may not be justified under those circumstances. But in bigger cases, I'm not sure it's going to make a significant difference one way or the other.
So Joe and Brian, we got about 4 minutes, or would you like me to head in terms of the slides?
Do you want to do questions?
You know what? Let me do one just minute on the PPP issue, because I think that's one.
Down here at
Yeah.
SPN.
Let's go down to, yeah, the question of whether you can get PPP loans. So for those of you unfamiliar with the PPP program, a business is able to get a certain amount of funds if they have, initially it was they used the funds within 8 weeks after receiving the loan. It was 75% for payroll, 25% for rent, interest, or mortgages or utilities. There's been a change now. That threshold's been reduced. They're proposing an extension to 24 weeks or December 30th, 2020, whichever is earlier. But this goes back to your planning stage, which is there is just a multitude of various litigations around the country, which is, can you actually access PPP loans in bankruptcy? The CARES Act is silent. It does not require, it says nothing about whether you're in bankruptcy or not as to eligibility. However, the SBRA, the Small Business Association has engrafted requirements that you cannot be a debtor in bankruptcy and you can't be a debtor in bank at the time of the application, or if the funds are dispersed at the time the funds are prior to the funds being dispersed. So what has flowed from this is this question of, well, is this unfair discrimination by a governmental entity regarding a grant under Section 525A? And we have seen a split of authority, which I'm sure will make it up to the circuits, with a variety of courts finding that it is impermissible discrimination and others finding otherwise. And I just want to share an example where the debtor won the battle but didn't win the war, and that was in the bankruptcy court for the District of Maine. The court held that it was unfair discrimination initially kind of at the TRO level, but then determined really it's not a grant that's under 525, but is a loan, and it's a loan with favorable terms. So if you satisfy the requirements of a PPP loan, that's forgiven, but it doesn't convert it into a grant. It's really just a very nice, favorable loan you've obtained. Another decision, which was recently came out of June 4th out of Georgia, and this actually isn't even on the slides because our slides predated the June 4th decision. Yeah. But this was Henry Anesthesia Associates, where it said even though this rule that the SBA has required is discriminatory, it's not impermissible discrimination under 525A because it doesn't fit, this kind of CARES Act relief doesn't fit under the statutory language of other similar grants. So again, when figuring out what your game plan is, debtors counsel, you need to factor this in because I have to tell you, I'm sure litigation costs are spiraling, and the SBA has been very proactive and also has taken a very firm stance on this. I don't think there's room for negotiation at this point.
Right, and companies, I was going to say, companies around Chapter 11 are companies that need the PPP. I also wanted to throw in, I think there's going to, well, I should say, I think there's some legislative interest in the legislative fix, but we'll see whether that actually comes. And Brian?
Yeah, one other thing on the Penobscot case, Judge Fagone, he handed down an opinion just about 2 or 3 days ago in that case, and I have not read it, but if anybody's interested, they should look at it because I know he changed his mind about a couple of things. And I know him personally. If he actually wrote a real opinion, I expect it to be a very good opinion because he is a very smart man and a good writer. So I just wanted to throw that out there. It flashed across my email, I think, 2 days ago.
Yeah, I think that's right. And I think, I mean, I just looked at my phone here. So we're a minute past. So I think we could spend much more time talking about the PPP issue. And again, right, it's companies that are in financial distress are the companies that need these loans. So I think there's a lot of action right now in that program with Chapter 11. So we've reached the end of our hour. So I'll stop there. I see Heather has posted in the chat about, it says, thank you for joining us today. If you did not register on the College of Law website and would like seal e-credit, please email Heather your Illinois ARDC number, and she's left her email there. So that's in the chat. You could also find Heather Ball. You could also find her email on through the internet. Let me thank our 3 panelists, Jill, Jamie, and Brian, for joining us and the time they took this afternoon, but also the time they took to prepare for this. lot of information in a short period of time. Hope it's been useful for everyone. If you have some questions, I'm going to hang around for a few minutes, leave them in the chat. We'll try to answer them. But otherwise, thank you again for joining us. Goodbye, everyone.
Thank you.